Picture the federal courthouse in Providence, Rhode Island, gray stone against a cold sky. Inside, Judge John McConnell reads a ruling he does not wish to make. The president's men, he finds, have broken his order to unfreeze public funds meant for lawful purpose. Yet he stays his hand. No contempt, no punishment, only a pause. The air in that courtroom holds still, as though justice itself were waiting to see if its words still carried weight. What makes a judge stop short when disobedience stands plain before him? He paused not from weakness, but from warning. The moment marked more than a dispute over dollars. It was a measure of the nation's obedience to law itself. And in that quiet pause begins a story older and deeper than any one name. When one branch of our government questions the right of another to speak, the Republic enters dangerous ground. The courts have no army, no treasury. They wield only judgment, and the people's faith that judgment will be honored. If that faith breaks, what then becomes of liberty? Now imagine the marble halls of the Supreme Court, where a handful of citizens, lawyers, clerks, and judges, stand between order and chaos. They wait for the executive branch to heed, not for their own pride, but for the promise that binds us all. But there is something about this moment that most have not stopped to consider. For every time power tests the fence of law, the question is not who wins, but whether the fence still stands. The Brennan Center reminds us, a court may fine, may compel, may punish by contempt. Yet even such instruments depend upon obedience through the hands of the very officers who might defy them. It is a paradox old as government itself, law dependent on the lawless. If a judge's word can be ignored, what then becomes of law? The answer, plain in history, is that disobedience at the top invites an avalanche below. During the crises of the 1950s, when Arkansas defied desegregation orders, President Eisenhower called on the 101st Airborne to escort children to school. He did not agree gladly with every court command, but he obeyed the Constitution that made them binding. Picture Little Rock's Central High, 1957. The sandbags, the jeers, the soldiers escorting black students through hostile streets. It was not politics that walked beside them, but law in uniform, reclaiming its dignity step by step. Across our history, presidents have grumbled but obeyed. Nixon turned over the tapes. Truman accepted defiance from his own court. More than once, strong leaders yielded because they understood that resistance to lawful order is resistance to the nation itself. The courts command not through fear but through legitimacy, an invisible thread that no bayonet can guarantee. And still, the question endures, what if that thread were cut? What power compels faith when faith fails? The courts can turn to contempt, civil to coerce, criminal to punish. They can summon the marshals, as the Brennan Center notes, and even appoint private prosecutors if the Attorney General will not act. Picture the Marshals Service headquarters in Arlington, rows of badges gleaming under fluorescent light, each one a promise that a judge's word can still be carried out by hand and will. Yet these tools, though lawful, are last resorts. They are hammers where the founders hoped reason would suffice. The Constitution presumes duty before defiance. Washington, Jefferson, even Jackson, each challenged the courts in words, but all submitted in deed. They knew that the rule of law is not an ornament upon power, it is power's leash. The courts have power, yet no army. Their might exists only where conscience responds. When a president obeys an unwelcome ruling, he does more than yield an argument. He keeps the promise that the governed and governing remain under one rule. Without that, we fall into the rule of will, where every law bends to appetite. Imagine the East Room of the White House in the dim evening, an executive staff gathered around a table, debating whether to comply. Voices rise, pride tempts, history watches. The choice is heavier than any policy, obey the court or obey the urge to rule alone. That is the measure of man and office. History has already tested this once before. In 1952, President Truman seized the steel mills during war. The Supreme Court said no. He obeyed. In 1974, Nixon faced the court's demand for his tapes. He obeyed, though it hastened his fall. These moments reveal that the greatness of office rests not in command, but in submission to law. Think, too, of modern faces: marshals waiting for guidance, attorneys bound by oath, citizens reading the morning papers wondering whether orders will be followed. Each heart measures the strength of the Republic not by rhetoric but by restraint. Perhaps restraint itself is the mark of power, for only the strong can lay aside the weapon of defiance and keep faith in the rule that limits them. Those who mock such restraint mistake patience for weakness, but endurance, not rebellion, built this union. On the steps of that Providence courthouse, the morning light strikes the stone where reporters once waited for news. They held their microphones like little scales of justice, hoping to weigh what it meant that a federal judge had ruled, yet hesitated to punish. Behind that hesitation lay not silence but warning, that obedience cannot be forced forever. It must be chosen anew by every generation. Picture Judge McConnell leaving his bench, the burden of the robe heavier than it looked. He walked through the same doors where portraits of other judges hang, men and women who once faced contempt, perjury, and defiance, but still trusted that their word would outlive any single rebellion. What was he thinking in that quiet? Perhaps that punishment might win a battle, but lose the principle it meant to guard. Here the story grows larger than one courtroom, for in every age the struggle repeats. When power meets restraint, something in the human heart must decide which shall rule. The founders expected this tension. They framed it into the machinery of government, believing ambition could counteract ambition, at least until virtue had a chance to speak. In their design, no branch is master. The executive executes, the legislature legislates, and the judiciary judges. Yet all are sworn to the same constitution. A president, though chosen by millions, becomes not their will made flesh, but the servant of a written law older than any vote. That truth is what holds the Republic upright. Think of Philadelphia, summer of 1787, the hall hot with argument, Madison speaking of checks and balances, Hamilton warning against unchained power, Washington presiding in silence. Those men knew kings and mobs alike could destroy freedom, so they bound power in parchment, trusting that character would give it breath. And what of character today? It is tested not when the law is easy, but when it contradicts our preference. Every citizen knows that impulse, to wish the rule bent just this once, for cause we believe right. That temptation is as old as Eden and as perilous as tyranny itself. For when each man picks which law to honor, law soon honors none. Picture a clerk in a quiet office in Providence, typing the words of that court order into the record: compliance required. Simple words, yet behind them stand centuries of blood and argument. Those words mean that a judge, one citizen among millions, can still call government itself to account. That is no small miracle. When that power is ignored, the miracle fades. Some say presidents should lead by instinct, not by legal leash. But instinct belongs to beasts, law belongs to men. The animal follows appetite, the citizen follows duty. The framers could not trust appetite to guard freedom. They built a cage of procedure, a constitution, and asked the people to love it enough to stay inside. Let us walk back through time a bit further. In the early Republic, Thomas Jefferson bristled when Federalist judges ruled against his acts. He feared the courts might rule the nation by decree. Yet even he, fierce in disagreement, complied. He argued, appealed, persuaded, but he did not defy. He knew that to keep self-government, one must first govern self. That lesson returned in our darkest hour. During the Civil War, when I suspended the writ of habeas corpus in areas of rebellion, the Supreme Court questioned my authority. History has debated that choice. But even then, when the storm had passed, the court's word resumed its course, and presidents after me renewed its command. The Constitution is not clay to be molded by only one branch. It is stone. All must stand upon it or fall from it together. Today's quarrel over a frozen fund in Providence may seem small beside those struggles, yet the principle it touches is the same. It asks not, who shall win this case, but, shall the law still be final? For the rule of law is like the heartbeat. It is only noticed when it falters. Imagine for a moment a world where each branch obeyed only itself. In that world, your rights would depend on favor, not fairness. Court orders would become suggestions. Elections would become wagers of will, not renewals of trust. And every man with power would find reason to call himself exception. We have seen such nations. They do not endure. And yet the American experience gives a strange comfort. We have stumbled before, defied before, shouted before, and still the law rose again. The reason is simple. The people themselves, more often than not, choose to bow to reason. Not all at once, not without pain, but enough to keep the chain unbroken. Think of the desegregation orders in Little Rock once more. Those children, their faces stern with courage, were not enforcing law with weapons, but with witness. Beside them marched soldiers, some uneasy, some proud, but all under command to restore obedience to the courts. That picture earned the world's respect because it showed that even power could kneel to principle. So too in Watergate, when aides delivered boxes of tapes to the special prosecutor's office. Their faces were pale, their voices tight. They were not heroes in that hour. They were servants of process. Yet by that small act of compliance, the country proved that no one, not even the highest, was beyond the reach of law. That quiet scene taught more about freedom than any anthem or parade. Now think again of today's courthouse in Providence. The judge's pause lingers still. Some call it weakness, but perhaps it was faith, a belief that the oath of the executive needs only time to remember itself. He chose patience over spectacle, trusting that duty might yet awaken. For he knew that contempt and conflict may wound the same body they mean to save. Sometimes, restraint itself preserves authority. But restraint cannot last forever. If disobedience continues unchecked, the rule of law grows sickly. Contempt orders, fines, the summoning of marshals, these tools exist for a reason. They remind us that freedom without enforcement is fiction. Yet each must be wielded with care, lest remedy breed revenge. Picture now the U.S. Marshals walking through the courthouse corridor, the seal of the Department of Justice above their heads. They act not for one man or party, but for the Constitution itself. In their hands, the voice of a judge gains weight. Through them, the people enforce obedience upon their own leaders, proving that in America, the ruler and ruled are both answerable to the same command. As light fades across that marble seal, one truth stands clearer. A republic survives not by might, but by mutual promise. The Constitution is only parchment, courts are only people. Its strength lives in the daily choice of obedience, by presidents, judges, clerks, and by you. If ever that choice were forgotten, what anchor would remain? Not wealth, not weapons, not words, only conscience. And conscience must be tended. Duty fades when citizens forget why it matters. Look to the future, then. The time will come again when a leader bristles at a court's decision, when millions cheer defiance as boldness. In that hour, remember Providence. Remember the judge who paused, the soldiers who marched, the citizens who complied even when hearts rebelled. That is the unseen discipline that keeps liberty alive. Perhaps you will stand one day at your own threshold of law, your will on one side, your duty on the other. It may not be in a courtroom, it may be at work, at home, at the ballot box. The struggle will feel quiet, but its meaning will thunder through the life of the nation. The Republic depends not merely on documents, but on your daily decision to respect their limits. Picture dawn breaking again over that federal building in Rhode Island. The flag lifts, slow in the wind. The same sun touches the White House roof and the Supreme Court dome. It glows across three branches still standing in tension, still serving one Constitution. After every test, after every pause, obedience returns, and with it, renewal. That is the secret strength of this union, not perfection, but persistence, not the absence of conflict, but the victory of restraint. Our ancestors pledged their lives to build it. Our children will inherit only what we honor by choice. So take this to heart, my friend. The rule of law is not self-sustaining. It breathes through you, through your faith that judgment has meaning, through your willingness to yield when the verdict says no. The nation's stability depends on that simple, stubborn act of respect. As long as that respect endures, the storm may batter, but the foundation will not fall. The courtroom may stand empty for a time, the judge's pen still, the president's words loud, but when the conscience of the people awakens, obedience will follow and law will live again. Yes, the Republic can be saved. When the moment comes, will you choose the comfort of pride or the courage of restraint?